Welcome back. I'm Richard McAdams, and a key theme of this upcoming panel will be the formative influences of Earl Dickerson. I'm pleased to be introducing our two presenters, Professors Thaxton and Strauss. Sherod Thaxton is a professor of law at UCLA Law School. He earned his JD here at the University of Chicago Law School, and so we are happy to welcome back our alum. He earned his PhD in criminology from Emory University, and I am pleased to say that before moving to UCLA, Professor Thaxton spent some time here as a lecturer, including time as our very first Dickerson Fellow. Professor Thaxton teaches and writes about criminal law and procedure, the sociology of law, and empirical legal studies. He will present remarks titled, "To Inspire Service in the Public Interest, Earl B. Dickerson, Kappa Alpha Psi Fraternity and Social Movement Lawyering." My colleague, David Strauss, is the Gerald Ratner Distinguished Service Professor of Law here at the University of Chicago. Professor Strauss is a practitioner, scholar, and theorist of constitutional law, and has written and taught extensively on the Equal Protection Clause of the 14th Amendment and its applications to matters of racial justice. He will present remarks titled Earl Dickerson's Constitutional Law Class. As with the other panels, at the end we will have time for questions, and I will ask you to signal your interest in asking a question by raising your virtual blue hand or by sending a private chat message to me, Richard McAdams. So I ask the speakers to limit themselves to no more than 25 minutes. And with that, I turn the Zoom spotlight over to Professor Thaxton.
Thank you very much for that kind introduction, Richard. It's great to be back at UFC, albeit virtually. And it's great to see some familiar faces in the gallery. So on August 10th, 1986, Kappa Alpha Psi Fraternity held its 75th Diamond Jubilee Conclave in Indianapolis, Indiana. The fraternity's Diamond Jubilee was unlike any other national meeting that had been held in the fraternity's history to that point. It had more than 2,000 attendees. Tennis great Arthur Ashe, well known at the time for his civil rights work, was awarded the fraternity's highest honor, the Laurel Wreath Award. Another Laurel Wreath Award awardee was Congressman George Crockett, a former judge and former vice president of the National Lawyers Guild, who was famously held in contempt of court and sentenced to jail for his efforts as an attorney to defend 11 Communist Party leaders convicted of violating the Smith Act. Now, Mr. Crockett appealed his conviction all the way up to the U.S. Supreme Court, which granted cert in the famous 1952 case, Satcher et al. V. United States. Now, Mr. Crockett was defended by, among others, another Laurel Wreath awardee, Earl B. Dickerson, who had received the fraternity's highest honor, the Laurel Wreath Award, nearly 40 years earlier. Now, at that Diamond Jubilee celebration, a 95-year-old Earl B. Dickerson, who was also a former national president of Kappa Alpha Psi Fraternity and the fifth person ever to serve in that capacity, established the Earl B. Dickerson Endowment Fund with a $15,000 gift to the fraternity. He remarked at that celebration, and I quote, "I wanted to do something for the organization that had done the most for me socially." Unfortunately, he passed away the following month. Now, at that time, he was the second oldest living member of Kappa Alpha Psi. Now, oddly, in his obituary appearing in the New York Times on September 4th, 1986, which was 3 days after his passing, there was no mention of his involvement in Kappa Alpha Psi Fraternity. Now, the official text of the fraternity, The Story of Kappa Alpha Psi, A History of the Beginning, Development of a College Greek Letter Organization, is now in its 5th edition. Now, the most recent edition chronicles the history of the fraternity from 1911, well, actually 1910, through 1999. Now, when one begins to read the text, it becomes very obvious very early on that the story of the fraternity, along with its role in the struggle for racial justice and civil rights, cannot be properly told without also telling the story of Earl Burrs Dickerson. Now, trust me, this is no exaggeration. Mr. Dickerson named appears 40 times in the book's name index, okay? And the index probably missed a couple. So while Mr. Dickerson said when he established the endowment for the fraternity that he wanted to do so because the organization had done the most for him in his social life, it's equally true that Mr. Dickerson, along with a handful of other individuals, has done the most for the fraternity that currently boasts over 150,000 members and over 700 chapters operating at the undergraduate, alumni, and international levels, and an organization that includes countless notable members involved in education, arts, entertainment, business, politics, law, religion, theology, sports, science, you name it. Although I was the inaugural Earl B. Dickerson Fellow and lecturer in law at the University of Chicago, as Richard mentioned, my connection to Earl B. Dickerson occurred long before then. In fact, my connection to Mr. Dickerson occurred before I was enrolled as a student at the University of Chicago Law School and became a member of the Earl B. Dickerson chapter of the Black Law Students Association. In fact, my connection to Mr. Dickerson came 12 years earlier in 1993, when I became a member of Kappa Alpha Psi fraternity after being initiated into the Iota Sigma chapter at the University of California at Davis, exactly 80 years after Brother Dickerson entered the bond of the fraternity. Kappa Alpha Psi fraternity was founded by 10 Black college students on the campus of Indiana University in Bloomington, Indiana on January 5th, 1911. Brother Dickerson's name appears in the story of Kappa Alpha Psi early, and as I said before, it appears often. In fact, only a few pages into the fraternity's history, one encounters mention of him. Brother Dickerson was a student at the University of Illinois, and with a group of other students, he formed an organization called the Ilio Club, and then surprisingly, he was its first president. Now, several founding members of Kappa Alpha Psi, along with a handful of early initiates, were concerned about the level of isolation felt by Black male college students. It was well known that the harsh realities of anti-Black racism were similar in both college communities, that is Bloomington and Champaign and Urbana. Housing for Black students was scarce, and many of them had to wait tables for their board. There were no restaurants in Champaign where they could eat, and only one restaurant in Urbana. Now, after hearing about the Ilio Club, these Kappa men traveled from Bloomington to the University of Illinois to discuss the possibility of the club becoming the second chapter of the fraternity of Kappa Alpha Psi. Now, after a meeting between the members of Kappa Alpha Psi and the Ilio Club, Brother Dickerson, along with 8 other members of that club, became charter members of the Beta chapter of the fraternity, its second chapter, on February 8th, 1913. Unsurprisingly, again, Brother Dickerson became the chapter's first president, referred to as Polmark. And the Beta chapter occupied its first fraternity house in October of 1915. Now, as one of the fraternity members remarked at the time, the house marked the beginning of a new life, a life that from all indications would carry Beta chapter to the front ranks of fraternal organizations at the University of Illinois. And as a quick aside, with respect to Black women, the first Black sorority, Alpha Kappa Alpha, was founded 3 years before Kappa Alpha Psi on the campus of Howard University, and chapters would emerge in Chicago and University of Illinois around that same time. Now, the Alpha chapter at Indiana University and the Beta chapter at Illinois were remarkably successful in the achievement of its members. And the story of Kappa Alpha Psi expressly refers to Brother Dickerson's teaching position at Tuskegee Institute after he left the University of Illinois. Now, at the next national meeting of the fraternity held in December of 1913, there were about 75 participants there, and Brother Dickerson was elected the Grand Vice Polmark, which was equivalent to the National Vice President. Now, the country's involvement in World War I greatly impacted the fraternity's growth, as relatively few men returned to college in the fall of 1917 because of uncertainty surrounding the draft. Now, recognizing the growing numbers of alumni members in the fraternity, in Chicago, and the need to establish a chapter for these members to return the fraternity to distinction after the interruption and expansion of the fraternity caused by the war, Brother Dickerson and others including 3 of the fraternity's founding members, chartered the fraternity's first alumni chapter, called the Chicago Alumni Chapter, on April 6th, 1919. Now, Kappa Alpha Psi was unique from other Greek letter fraternities at the time in that it decided to give its alumni chapters regional names rather than naming them with Greek letters, as was done for the undergraduate chapters. Now, this is important because the purpose was to give these chapters a distinct identity, which would become crucial in the fraternity's efforts to combat systemic racism. Now, at the 14th National Grand Chapter meeting of the fraternity, held in 1924, Brother Dickerson was elected Grand Polemarch in absentia. Now, again, he was elected in absentia. Now, this was a testimonial to the respect in which he was held by the membership. On his inaugural address the following year, he committed himself, he committed himself to changing the direction of the administration into a more forward-looking administration. So in the story of Kappa Alpha Psi, it refers to the years under Brother Dickerson's leadership as, quote unquote, a period of growth in chapters and in achievement that expanded the fraternity from a provincial organization of just a few ambitious youths in a single community to a national society of members who walk the high road in many cities and towns throughout the nation. At the 16th Grand Chapter meeting in 1926, Brother Dickerson gave a keynote address calling upon members to accept and discharge their responsibility for the service to Black college students and the larger Black community. Specifically, he urged active participation and deliberation between college and communities to eliminate racial discrimination. He also highlighted an increase in discrimination against Blacks in Northern universities resulting from increased Black enrollment. Now, central to his vision of the fraternity's role in the civil rights struggle was the use of the fraternal brotherhood to fight discrimination through the courts and by every other means at their disposal. He also underscored that high scholarship and extracurricular participation, such as bolstering African-American businesses and civic groups, were potent weapons that must be utilized. Now, if Brother Dickerson were alive today, his approach would likely be labeled social movement lawyering or even rebellious lawyering due to his emphasis on building relationships with community organizers to work for transformative social change at the local level, connecting lawyers, legal workers, and law students to assess collective capacity and build community, committing to using law to build power for impacted communities, and staying connected and engaged with other movement lawyers and impacted communities. Now, long after his tenure as Grand Polemarch, which lasted from 1924 to 1927, Brother Dickerson remained active in the administration of the fraternity. At its 37th Grand Chapter meeting held in Los Angeles in 1947, Brother Dickerson opened the meeting of 1,500 attendees by urging the membership to help America become a world leader by first combating racial discrimination domestically. In particular, Dickerson highlighted abolishing segregation at the Washington National Theater, with litigation efforts actually led by another fraternity member, Leon Andrew Ransom. Dickerson advocated for more Black faculty at predominantly white colleges and universities, and promoting the participation of Blacks in the Veterans Emergency Program. Now, 4 years later, Brother Dickerson would host a closed meeting of all past Grand Polemarchs, that is national presidents, at his home to discuss important matters concerning the direction of the fraternity for decades to come. At a subsequent meeting, he challenged the fraternity to, and I quote, make even bolder forays into the arena of public service. Now, for decades, Brother Dickerson helped shape the direction of the fraternity on the social acting front, excuse me, also, often with the imprimatur of 4 of the university's 10 founding members, who were also members of the Chicago Alumni Chapter. The fraternity, in turn, played an important role in Brother Dickerson's personal life and professional life. Under Brother Dickerson's leadership in the 1920s, Kappa Alpha Psi became the first Black Greek letter organization to use its national meetings to devise strategic plans regarding racial and social justice issues, and used its flagship journal, the Kappa Alpha Psi Journal to disseminate information about the broader social and racial justice movements to African-American college students and push against racism. Many of these nation's key civil rights attorneys were both mentored by Brother Dickerson and members of Kappa Alpha Psi fraternity who were connected to Brother Dickerson. And it is well known, Brother Dickerson's most famous case, Hansberry v. Lee, was a precursor to Shelley v. Kramer, which brought an end to racially restrictive housing covenants. But Brother Dickerson was connected to other key civil rights cases through the network of lawyers associated with Kappa Alpha Psi. As I mentioned earlier, he was elected to the fraternity's highest position, Grand Polemarch in absentia, and that was in large part due to his tireless efforts to not only expand the fraternity, but also pair this expansion with a racial justice agenda and strategy. Perhaps the first biggest civil rights win orchestrated by Kappas was during 1924, the year Brother Dickerson was elected Grand Polemarch, when two members of the fraternity, Brother Elisha Scott and R.M. Van Dyne, both charter members of the Topeka alumni chapter of Kappa Alpha Psi, litigated the precursor to Brown v. Board of Education, in the case Thurman Watts v. Boards of Education, and the Kansas Supreme Court. The case was extensively covered in several news outlets, including the fraternity's own journal and the NAACP's flagship journal, Crisis. Brother Scott would play a pivotal role behind the scenes in Brown v. Board of Education litigation, although he was not an attorney of record in the case. And he also represented victims of the Black Wall Street massacre in Tulsa, Oklahoma. Leon Andrew Ransom, who I mentioned earlier, who was most closely aligned with Charles Hamilton Houston when Houston was special counsel for the NAACP, was also closely connected with Brother Dickerson through their affiliation with the Chicago alumni chapter of the fraternity. Now, one of Brother Dickerson's most successful proteges was William Robert Ming, typically referred to as Bob Ming, who was initiated into the Iota chapter of Kappa Alpha Psi fraternity, which is located at the University of Chicago. And Brother Ming was also a graduate from the University of Chicago Law School. Now, he became one of the key attorneys in the landmark Supreme Court cases, Sweat v. Painter, McLaurin v. Oklahoma State Regents, and others, as well as Brown v. Board of Education. Brother Ming would later successfully defend Martin Luther King Jr. in a criminal case for perjury, obtaining an acquittal before an all-white jury. And one thing that the University of Chicago is particularly proud of is he also became the first African-American tenured law professor at an historically white institution, which was the University of Chicago Law School. Now, in 1974, the NAACP named one of its most prestigious awards after Brother Ming. Now, in an article published by the University of Chicago Law Record in the spring of 1991, titled Earl, Bob, and Me, was penned by University of Chicago law graduate and then former Cook County judge Ellis Reed, who graduated from UFC law in 1959. Brother Reed was also a member of Kappa Alpha Psi, and he noted in that article that Brothers Dickerson and Ming were the two men who had the most lasting impact on his life. All were UFC law grads, all were Kappa men. Actually, Brother Reed was an initiate of the Bader chapter, which was chartered by Brother Dickerson, and all dedicated their lives to fulfilling one of Kappa Alpha Psi's stated main objectives, which is to inspire service in the public interest. Now, Brother Reed expressly noted in his article that the achievements of Brother Dickerson and Brother Ming brought about lasting changes to society, but very few young people today were aware of those contributions. Now, Brother Mead only makes brief mention of Brother Dickerson's membership into Kappa Alpha Psi, but also notes that his article was simply an overview of a broader work in progress. Now, I never had the opportunity to meet Brother Dickerson or Brother Ming, but I was honored to have the opportunity to meet Brother Reed while I was a student at the University of Chicago Law School. A classmate of mine at the time, who was a member of an historically Black Greek letter sorority, happened to mention to Brother Reed that I was also a member of Kappa Alpha Psi. I did not know he was a member. At that point, he did not know I was a member. And as soon as she mentioned that, the conversation immediately took a turn from the professional to the familial. He immediately asked me where my chapter of initiation was. He gave me his private phone number. He invited me to an event that he was having at his home, and then began telling me about his relationships with Brother Dickerson and Brother Ming. last month I attended a virtual meeting of Kappa Alpha Psi brothers here in Los Angeles. And I mentioned to them at the time that I was asked to deliver some brief remarks about Brother Dickerson's involvement in the fraternity. One of the attendees at that meeting, Brother Herring, mentioned that he was a 1959 initiate of the fraternity at the University of Cincinnati, and that he actually worked with Brother Dickerson when he was in the Midwest, and then relocated to Los Angeles to work with former Los Angeles mayor and another Kappa Alpha Psi brother, former mayor of Los Angeles, Tom Bradley. Now, I had spoken with Brother Herring on several occasions before that, and although I was aware of his work with Mayor Bradley, his association with Brother Dickerson never came up. Needless to say, Brother Herring was very thrilled to hear that Brother Dickerson's influence in Kappa Alpha Psi would receive some much deserved recognition. Now, quoting from the obituary for Brother Dickerson in the Kappa Alpha Psi Journal, to call him a great man of our time is less than accurate. He was also an extraordinary presence in most areas that we are either too young or to know or either remember. He was always substantially more than the volumes of titles he held would indicate. He was first and foremost, to use his favorite expression, a citizen of the world. I am honored to have had the opportunity to shed more light on this particular aspect of Brother Dickerson's remarkable life. Thank you.
Thank you. So, Professor Strauss? Oh, you have to unmute. David, you have to unmute.
You would think by now. Thanks, Richard, for the introduction. I also wanted to thank all of you for coming, and also Sherod, great to be in the same space with you, even though it's only a virtual space. My subject is Earl Dickerson's constitutional law class, two classes. He took two classes in constitutional law. And here's how I want to go about thinking about this important subject. First, I want to say a few words about the era in which he went to law school and what implications that era has for constitutional law. And then I kind of want to go back in time and say, given what was going on in the world then, what would we want someone in Earl Dickerson's position to be getting out of his constitutional law classes if we were teaching him? What would we want him to be thinking about, learning, exploring in his constitutional law classes, given what was going on? Now, that's obviously an anachronistic question. We have the advantage of 100 years of development in the law in general, and specifically, we have the advantage of the civil rights revolution, to which, of course, Earl Dickerson contributed so significantly. The civil rights revolution affected constitutional law as profoundly as anything in the 100 years since he took the class here at the University of Chicago. And obviously also constitutional law looked very different back then, especially in areas where the development of the law has occurred mostly in the after the middle of the 20th century, meaning the developments traceable to the New Deal and developments traceable to the Civil Rights Revolution. But still, I thought if we asked, what might we have hoped ideally he would get out of his constitutional law classes on the issues that we know from his later career meant the most to him? So that's the second thing I want to talk about a bit. And then the third question, obviously, is something about what those classes actually taught to the extent we can reconstruct it. So let me begin with the era in which he went to law school. The darkest post-Civil War chapter in the United States' treatment of Black Americans, the darkest post-chapter since the Civil War and the abolition of slavery, that darkest chapter corresponded to the first decades of Earl Dickerson's life, including his time at the law school. He was born in 1891 in Canton, Mississippi. In the year he graduated from high school, he took a Mardi Gras trip to New Orleans and met some Black university students there. And he thought he would like to be with people like that. So he told his mother that. His mother had a relative in New Orleans. And after he graduated from high school, he went to a University of New Orleans prep school. And when he was later asked, much later in his life, when he was talking to his biographer, how did you pay for that? He said, well, I did some chores, and tuition wasn't that much. I did some chores. And as for transportation, well, that wasn't too much of a problem. I just bribed the porter on the railroad line and stowed away. So he spent a year at the prep school in New Orleans. A white teacher who knew him there thought he had a lot of potential and said she would pay for him to spend a year at the University of Chicago Laboratory Schools, a school affiliated with the University of Chicago. So he moved to Chicago in 1907. He later described lab schools as his first non-segregated experience. But he ran out of money after a year. He worked for a while, then he went to the Northwestern equivalent of the lab schools, a university-affiliated school, then to the University of Illinois, and entered the law school in 1915. In 1917, he enlisted in the Army, and then returned to the law school after that. His constitutional law classes he took in 1919 and 1920. And by then, he was almost 30 years old, and he'd seen a lot. He'd had an extraordinary range of experiences, really even for anyone, for any law student. Meanwhile, there was massive disregard of Blacks' constitutional rights in the South. And when I say disregard of constitutional rights, that was not even the worst of it. There was private and official violence that went well beyond just the violation of constitutional rights. And also, it's not just in the South. There was anti-Black violence in the North as well. There were outbursts of anti-Black violence in Chicago, where he was in 1919. And on some trips to the law school, he had to arm himself in order to protect himself against the threat of anti-Black violence from whites. But as far as the Constitution is concerned, what characterized this era was rigid segregation that started to be enforced right around the time that Earl Dickerson was born in 1891. Even after the abandonment of Reconstruction in 1876, Blacks continued to vote in significant numbers in the South, and some institutions were integrated, notably railroads. Schools were never integrated, but some institutions were. But beginning in 1990, rigid segregation and disenfranchisement enforced by law and private violence took hold in the South. And of course, as I said, he was born in 1891. The 15th Amendment guaranteed Blacks the right to vote free from racial discrimination, but Southern states contrived various devices, notably literacy tests and vague fitness requirements enforced by white registrars, and used those to disenfranchise Blacks. A pattern that continued, that last pattern about disenfranchisement continued to a significant extent, really up to the enactment of the Voting Rights Act of 1965, although it had been at least part of the South before then, but absolutely part of the de facto legal system of the United States throughout the first decades of Earl Dickerson's life, including his time at the law school. I don't know from the research I've done, which is incomplete, how much he was affected by the installation of this rigid system of disenfranchisement and Jim Crow enforced by private and official violence. I don't know how much he was affected by that, but he couldn't possibly have been unaffected by that. Okay, what about his classes then? We have transcripts, we have a course catalog. His constitutional law classes were both taught by James Parker Hall and the dean. Hall had written a treatise on constitutional law. He also had a casebook, which he assigned to the class. So, excuse me for a second while I go cough, which I'll mute. So we have some idea from Hall's writings what he would have covered in the class. Earl Dickerson's grades are hard to decipher, which, you know, if you're worried that sometimes things change, that hasn't changed. He got an 80 in Constitutional Law 1. There was a blank on his transcript for Constitutional Law 2. But apparently he did well because James Parker Hall, the dean, recommended him enthusiastically, along with Ernst Freund, another prominent professor, recommended him to firms. And then he interviewed with the firms, and the firms told him, sorry, we can't hire you. Our clients will never accept our having a black lawyer. So he started his own firm in Washington. In Chicago. The course catalog descriptions list very quickly a dozen subjects, all in general terms. None of them is totally unfamiliar to modern readers. There's things like separation of powers, intergovernmental relations, police power, privileges and immunities, impairment of contracts, the role of the judiciary, all these things, and none of them is a term we have never heard before. But that wouldn't ordinarily be a significant part. Some of those things, at least, would not today be a significant part of a constitutional law class. And there were a couple of things conspicuously missing. No mention of the Bill of Rights by name. There were some mention of individual rights, and apparently nothing about the First Amendment. Not surprising considering the state of the law of the First Amendment at the time. Equal protection was mentioned as one on a long list, due process and equal protection, but nothing explicitly about race. And judging from the treatise and the case book, equal protection at the time was mostly, not entirely, but mostly about things like taxation and business regulation. That was the core of equal protection and not race. Now, what would you want, the question I was mentioning before, what would you want someone in Earl Dickerson's position, as a law student then, to hear about, among other things, of course, in his constitutional law class, bringing together the obvious advantage we have of hindsight? I guess a couple of things. One is, what was going on in the South was a massive circumvention of established constitutional rights, voting rights, and the right to sit on juries. The right to sit on juries is not explicitly guaranteed in the Constitution, but the Supreme Court had established it in Strauss against West Virginia in 1880. The exclusion from juries was actually derivative from the exclusion from the voting rolls. If segregationist states could, the jury pool was chosen from the voting rolls. So if segregationists could keep blacks from registering to vote, they could keep them off of juries as well. And that's what they did. So these were established rights, no question about it. Strauss against West Virginia is in Hall's casebook. The circumvention of voting rights was obvious. And you would certainly think one thing you'd want to talk about in the constitutional law class is, okay, what do we do in this situation? Here we've got constitutional rights that are indisputable. One is in the text, the other well-established precedent. Really no one is questioning. They apparently exist for many Black people in name only. They're not enforced. Is that a doctrinal failure? Is that an institutional failure? What do we do about this? You'd think that would be an important subject. Now, Hall, in his book, does address this. One of the ways of excluding Blacks from voting was the so-called grandfather clause, which set up these hurdles like literacy tests and various fitness requirements nominally for all voters, and then said, but if you were voting already before the Civil War, or you had an ancestor who was voting, or if you lived in a foreign country then, you don't have to pass these other requirements. And obviously that was meant to exclude everybody except the descendants of slaves from voting. And the Supreme Court was onto this in a case called Gwynn against Oklahoma in 1915, when Earl Dickerson was in law school. The Supreme Court said that form of grandfather clause was unconstitutional. And Hall says that as well. He says it's not totally unequivocally, but he says it's really hard to see how that can be constitutional given the 15th Amendment. But okay, then the question is, what is to be done? And at that point, what Hall's book does is to cite an opinion written by Justice Holmes called Giles against Harris, a very odd opinion in which Holmes, also confronted with an obvious effort to circumvent the 15th Amendment, says, you know, this is a fraud But there's really no point in entering an injunction against this because it'll never be enforced. If we're going to put an end to this fraud, the courts aren't going to be able to do it. So we're not going to enter an injunction. I'm paraphrasing a little, but that is the essence of the opinion. And Hall cites that on the question of what is to be done about this circumvention. I've only looked a little bit at Hall's biographical information, but one of his obituaries actually describes him, at least in part of his career, as an admirer of Holmes. So not surprising, I guess, he would sign on for that aspect of what Holmes did. What about juries? They're discussed in the book. Strouder against West Virginia is a case in the case book, but on that issue, there was no apparent awareness by Hall that by the time he was teaching Earl Dickerson, Strouder against West Virginia had become essentially a dead letter, and that while a state could not enact a statute saying juries are to be all white, it could essentially ensure that jurors would be all white by covert means. And there's no suggestion in either the case book or the treatise that that's going on, or that what might be done about that. Then the other thing I sort of looked into was segregation in general. The fact is, segregation in general at that time was probably not a big issue. It's actually pretty well known that Plessy against Ferguson, the notorious case that more or less ratified the doctrine of separate but equal, upheld the constitutionality of Jim Crow, decided in 1896, was effectively overruled by Brown against Board of Education. That decision was not a big deal when it was decided. It was buried in the middle of the New York Times. It was not big news, and only became big news actually in the 30s when a Black historian named Carter Woodford made it big news. But so at the time, probably the idea that most facilities would be segregated was just not seen as, at least by white people, and maybe by Black people as well, certainly by white people, as not particularly troubling. And in Hall's books, Plessy gets one sentence, and the book presents it as a police power case. Here are various reasons you can restrict economic activity, health, welfare, morals. Here's an instance in which a state ordered segregation in order to keep the peace. Next issue. No hint that was an equal protection issue. And as I said, that was probably the view among legal elites at the time. Now, here's another thing about this period in which Earl Dickerson was at our law school. There are 4 cases decided in the 19-teens that in retrospect are significant and really, in some ways, quite significant. The James Parker Hall books were published before they were decided, so I don't have any way of figuring out, at least that I could think of, how they were handled in Earl Dickerson's class. But here were the cases. A case called Bailey against Alabama that held that Alabama could not enforce a peonage law, a law that made it a crime to break a contract for personal services. These laws were pretty obviously efforts to recreate slavery by getting Black people to agree to contracts to work, and then if they wanted to quit on terms that weren't specified in the contract, they'd breach their contract and they could be prosecuted. The Supreme Court said, no, that's peonage. That's actually violating the 13th Amendment. A case called McCabe against the Atchison and Santa Fe Railroad. And remember, this is the era of separate but equal. In McCabe, a state authorized a railroad to provide luxury accommodations, as they then were, a sleeping car basically, for white people but not Black people. The justification was that there's not enough demand among Black people. This was attacked as being inconsistent with, as being unequal. And the attack succeeded. And the court said, no, you can't discriminate because Black people don't demand sleeping accommodations. Everybody's entitled to equal treatment as an individual, not as a group, which for the era of separate but equal is a pretty surprising step. And really, you can sort of, if you follow that thread, you can really follow that thread all the way to Brown against Board of Education. A third case was Gwynn against Oklahoma, which I mentioned, which struck down the grandfather clause, and then Buchanan against Worley, which declared unconstitutional a so-called checkerboard ordinance that prohibited people of a race from buying a home in an area inhabited by people of a different race. So a state could not insist that there were black neighborhoods and white neighborhoods, and you could only live in your neighborhood. And the Supreme Court said that was unconstitutional. The decision is largely written in terms of property rights, but there it's really not much of a leap at all to say, well, that checkerboard ordinance is exactly separate but equal. And if that's unconstitutional, what happens to separate but equal? Now, no one read the cases that way. I think there was some talk in the newspapers that maybe the grandfather clause case was a big deal, and maybe this was a sign that the courts would actually crack down on these subterfuges that Southern jurisdictions were engaging in, but that didn't happen. No one saw the possibilities in these other cases. It's really in retrospect that we can look back and say, if you're trying to build a case for Brown against Board of Education, if you're trying to do that in 1954, or even today as a matter of justifying it, you know, it really was anticipated by the case about the sleeping cars and the case about the checkerboard ordinance. But if you were to drop one of us into a classroom back then, after those cases had been decided, I think we would say, okay, here's some openings. The climate now in the country is terrible, but for whatever reason, the Supreme Court decided these cases, upheld the claims of the Black plaintiffs in these cases, and maybe they are entering wedges that we can use to ensure that the constitutional rights of Blacks can be enforced, at least to a greater extent than they are now. I think that's how we would have done with those cases, as I said, if we were to be dropped back into Earl Dickerson's classroom today. Did James Parker Hall use these cases in that way? I don't have direct evidence. I don't really have a good sense of what he was like. From what I can tell, it's extremely unlikely, not because of anything specific to him, but legal elites' attitudes at the time about race discrimination seem to have been that obvious denials of constitutional rights are unacceptable. You pass a law saying Blacks can't serve on juries, that's unacceptable. Pass a law saying Blacks can't vote, that's unacceptable. But beyond that, it's just the treatment of Blacks as second-class citizens or worse in the South particularly. That was just the way things were. That was not something that aroused a lot of passion on the part of legal elites, including legal elites who are otherwise quite passionate about what we might think of as progressive causes, about the causes of workers, for example. It's not that they were enthusiastic about Jim Crow, or even that they thought it was okay, but it wasn't part of the cause. And I don't know of any reason to think that what came through in Earl Dickerson's constitutional law classes varied from that attitude. Blatant violations of constitutional rights, we can't have those. We have a constitution, we have to observe it. But these other things going on, look, this is just the way things are in the South, and end of story. You have to remember this is an era in which Woodrow Wilson showed the birth of the nation. And so to say it's overtly racist is to understate the film that glorified the Klan. He showed it at the White House, in the White House in 1915, the year that Earl Dickerson started law school. The so-called Dunning School view of Reconstruction was prevalent among intellectual elites. The Dunning School view was that Reconstruction was a matter of a vengeful, corrupt Northerners and Blacks terrifying white Southerners, and that the end of Reconstruction gave the South a chance to rebuild itself. A school that's subsequently been discredited, but by then, at that time, that was the received view, that Reconstruction was a bad thing, a terrible thing, its own form of corruption and terrorism. Of course, the opposite was in fact true, that what went on after Union troops were withdrawn from the South was a reign of terror. No one on the Supreme Court, one possible exception, championed the rights of Blacks. There was no one on the Supreme Court who was writing opinions, even every now and then, saying, look, do you know what's going on in this country? Do you realize what's going on? Don't we need to do something about that? No one in the court said that no one in the court seemed, at least in official pronouncements, to be particularly solicitous of blacks, with one exception. The exception, interestingly enough, was Charles Evans Hughes, whose grandfather, I think, had been an abolitionist. And Charles Evans Hughes actually wrote a couple of opinions upholding the rights of blacks. But otherwise, this is a court with Holmes and Brandeis on it. And while Brandeis in private apparently saw Jim Crow and the treatment of blacks and lynchings were horrible and scandalous, was very, did not make public pronouncements, and certainly that wasn't in his opinions. All the presidential candidates at this time of both parties, not just Wilson, but the Republicans, historically, of course, the party that supported the rights of blacks immediately after the Civil War, they were all appealing to Southern whites at this point. And blacks and supporters of black rights really had nowhere to turn. So as far as, at least I could tell, the idea that something had to be done about a flagrantly unconstitutional, authoritarian, undemocratic system in the South, supported by private terror, the idea that something had to be done about that was not widely held among people like James Parker Hall. Many definitely approved and did, as I said, draw some lines at clear violations. And maybe Hall was an exception, and I'm selling him short. That's certainly possible. But while Earl Dickerson was probably given some of the basic materials he needed to contribute to the civil rights revolution as he did, the inspiration to use the law as an effort to change things, as a way to attack these problems, really, rather than just react to them passively, that inspiration and the determination to do that came from within him.
Okay, David, are you done?
Yes, thank you.
Okay, thank you very much. So now let me remind people we have time for Q&A until 1:35, and you can you can send a private chat to me, or you can raise your virtual blue hand. But right now I'll start by asking my own question. I guess I have different questions for each of our presenters, for Professor Thaxton, how wonderful it is that you could give us this history that has been not well stated, and to bring to talk about your own involvement with Kappa Alpha Psi. And I looked at that. I took the time to go and look at that obituary in the New York Times you mentioned. It is odd that it doesn't mention this. It does mention, for example, that Earl Dickerson, after World War I, founded an American Legion post in Chicago, one of the few founded by Black military personnel, but not Kappa Alpha Psi. And I guess I thought I would just ask you if you have any idea why this aspect of his life is underappreciated. I have an idea which is probably wrong, but let me just throw it out there as a reaction, which is I think that it was undoubtedly a white writer who wrote this obituary. I think that it would be obvious to white people that there is a organization that was important in civil rights, which were Black churches, but maybe that has gotten through, but maybe not so much this kind of fraternal organization, and that just leads me to wonder: is this a secular organization? Did it have any kind of religious commitments to it? Just tell us more.
Well, thank you for your question. Thank you for your question or questions, Richard. So I'll start with the last. With respect to it being a secular organization, no, actually, in its bylaws and its constitution, very much founded on Christian principles. I can't go too much in it because all obviously quote unquote secret societies have their own rituals and symbols and so forth. So I can't give you that much. If you want to become a member, talk to me offline. But I will say definitely no. it wasn't a secular organization. And in fact, there were, again, you could say for fraternity church partnerships throughout. But when you ask, why is this aspect of Dickerson's life not been given, I think, due appreciation? There's a couple of answers. And so I think, one is, I think, perhaps timing. He joined the fraternity in its infancy. So the fraternity was founded in 1911. As I said, he became a charter member of January 5th, 1911. He became a charter member in February 8th, 1913. Okay, so in the second chapter. And so a lot of that work was unappreciated because the fraternity was not a known quantity. It also wasn't the first Black Greek letter organization, leads to my second point. So the first Black Greek letter organization is continuing existent. It was founded at Cornell University in 1906 by the name of Alpha Phi Alpha. Now, Alpha Phi Alpha had very high profile members, and their affiliations with Alpha Phi Alpha were noted. So individuals such as Thurgood Marshall and W.E.B. Du Bois were members of Alpha Phi Alpha. And so Martin Luther King. Okay, so when you have those names in that organization, that affiliation is much stronger. So when you think about the organizations and their work in the civil rights struggle, you tend to think about Alpha Phi Alpha. Now, interestingly, a law professor, Gregory Park, who's at Wake Forest University, has written a series of articles. He's a member of Alpha Phi Alpha, but he and some co-authors have written a series of articles about the role of Black Greek letter organizations, both fraternities and sororities, in the civil rights and social justice learning. And I think through that work, and hopefully conferences such as these, the connection that Dickerson's connection to the fraternity, and also how that influenced not only his approach to social justice learning, but the fraternity's kind of organized approach, not just Kappa Alpha Psi itself, but also in connection with other.
Yeah, we ain't alphas.
Oh, so I think someone had wanted to add a little bit, but I think that you had those connections that over time became that became strengthened. So I think that answered multiple of your parts, but I don't know if there's something I left out, Richard.
Yeah.
Okay.
No, thanks. That's good. I understand better. David, Professor Strauss, I guess the end, the way you ended makes me want to really ask. I guess you were leading up to this point, which I was going to ask, which is, where did Earl Dickerson get this idea that that the law could help and the movement? And the dean this morning read this letter that Earl Dickerson wrote in the 1980s, towards the end of his life, to Gerhard Casper, the then dean at the law school, in which he talked about having decided to go to law school because he thought that maybe the law was a source of improvements and a tool for change. So let me so that's sort of puzzling. Let me combine that with the question about the NAACP. So the NAACP Legal Defense Fund brings many of the cases that during Earl Dickerson's life changed law, equal protection, and Dickerson board of that organization for 3 years, from I think it was 1941 to 1971, I guess that organization consisted of people who had this idea that the law could be a force for change, and I get, where did it come from? I mean, was it Harlan's dissent and Plessy that there were the seeds of a different view of the 14th Amendment?
It's a great question. And Plessy itself was a staged case. I mean, it was a setup in which the streetcar company cooperated to try to get at segregation. It was carefully chosen. They chose New Orleans because it was a place where there was less hostility than elsewhere in the South. They chose Plessy himself because apparently when you looked at him, you couldn't tell he was black. He was only 1/8 black. So he didn't look black, which heightened the absurdity of telling him he couldn't sit with white people in the streetcar. So this was all carefully staged. So the idea was there before. And as you said, Richard, the NAACP certainly did that. It would be possible to sit in a constitutional law class and look at these decisions, and especially if he had the surprising decisions that I mentioned, the 4 that came out in the 19 teens when he was either in law school or about to enter law school, look at those decisions and thinks, okay, I see some possibilities there. And just figure that out for yourself. And maybe sort of his larger climate, his association with other Black people gave him some ideas along these lines. I guess what struck me was that while there was among legal elites, there was sort of an idea that you use the law instrumentally, you use the law to achieve, progressive goals. For example, Louis Brandeis made his career before he went on the court that way, that you don't see among legal elites anyone, among white legal elites at least, anyone saying, you know what, this should be an area in which we should be doing the same thing. And here are some cases that, there are some doors here, potential doors to push open here, or at least get part of the way in the lower courts, because the Supreme Court has done things that seem to undermine separate but equal, seem to undermine the subversion of seem to make it harder to subvert the right to vote and the right to sit on juries. And you just don't see that. So either he got it from people he associated with, or I could imagine if he went to law school with the attitude that part of what I want there is to think about how I can make some progress on these issues. He didn't need his teacher to tell him. And maybe Parker Hall did tell him, James Parker Hall did tell him. I don't know. I just don't have any reason to think he did. I don't need my teacher to tell me. I can figure this out and pick it up and run with it. Myself. It's possible that way of thinking about the law, although there were these litigation efforts, that way of thinking about the law, it's possible that is an anachronistic criticism in the sense that the reason we think about that potential in the law today, that is to say, here's a decision, can we push it in a certain direction in order to establish, you name it, reproductive rights, women's equality, or for that matter, gun rights, the rights of religious groups. Here's a decision, how far we can push it. It's possible that way of thinking is itself the result of the NAACP's work. And so it was it doesn't make any sense to say, to speculate about whether that was something that the way people thought about the law back then. But I don't see any reason to think that this was, that what Earl Dickerson ended up doing was other than self-generated or possibly generated by his associations with the Black community. He was certainly respected by white legal elites, and was a student that the faculty at the law school thought well of and promoted. But I don't see any indication that they gave him that idea.
Thank you. Let me call on Vice Provost Daniel Ababa.
Thank you, Professor McAdams. That's very generous of you. It's always a pleasure to learn from Professors Thaxton and Strauss, so thank you very much for your presentations. I have a quick question, I think, for each of you. For Professor Thaxton, I think you pointed out very well the centrality of fraternities in, certainly with respect to Dickerson and Ming, and maybe more so with respect to the civil rights movement more generally. I wonder if there's the same impact today of these fraternities in the movements that we see in the current moment and that we've seen in the recent past and we're likely to continue to see. So I'm wondering if you just have any thoughts about associations or the role of these fraternities in movements going forward. My question for Professor Strauss, I think, builds on where I think you ended. I completely agree with your conclusion that despite incredible obstacles, Dickerson was extraordinarily self-directed, ambitious, hardworking, and had all the qualities that I think we've seen demonstrated through his life. it is still interesting to think what the university may or may not have done. It could very well have been that the law school pushed him in ways to make him think that law was not a tool for social change, or it could very well have done gone the other direction. I'm curious if we have records of the exams that James Parker Hall may have put together for his students in constitutional law class. The questions he may have asked may have gone to your point about, did he frame it as a police power question or did he frame it as something else? And that history might be available. And then secondly, if we know if there's contemporaneous scholarship from Hall or Freund, given that both of them wrote letters of recommendation for Parker, they may have in their legal scholarship hinted their views on these things, which may very well have been present in the courses they taught. Thanks for the opportunity to participate.
You can go first, David.
Yeah, Daniel, great, obviously great questions. The writings that I don't have his exams. That's a great idea. I wish I had his exams. And if we can dig them out of the archives, that would be a real much better indication of what the class was about than anything else, certainly than the course catalog or the treatise and casebook, which don't tell you how the course was focused. So that would be great if we had those. Whether he got, and as far as, I don't know Freund's writings, I didn't see anything in the works of Hall that I read that took this approach, that you can see law as a systematic way of getting to a more just world. Now that I could be selling him short, I haven't done an exhaustive search. I certainly haven't done exhaustive work on his life. I really just read some of what he's written in these areas, but I didn't see that. I wasn't looking for it in general. I didn't see, I was looking for it about race and I didn't see it about race. As far as what the law school did, a plausible account. I mean, this is clearly a really exceptional guy. I mean, he was born in Mississippi in 1891. For heaven's sake, you think of how many Black people born in Mississippi in 1891, even people of enormous talent and advantages were probably had very unfulfilling lives because of what the society was doing to him. And he, with help from a lot of people, but still he got himself out of there. The one thing that kind of has stuck with me is the extent to which being in the North, being in Chicago, being at the University of Chicago, both at the lab school and the law school, and also being in Evanston and affiliated with Northwestern. Evanston at the time apparently was seen as a place that was unusually receptive to Black people. More so than Chicago, that being in those places and then being kind of celebrated by the law school, at least to the degree that the dean was willing to go to bat for him, that gave him a sense that it gave him some sense that he could do some things that maybe he didn't have before. Now, maybe he had it all along, but it wouldn't shock me if someone who had this trajectory, the reason that his Chicago experiences were crucial, and this is just the normal human reaction, is that they eliminated a level of self-doubt that would be hard to believe did not exist in a Black kid born in Mississippi in 1891. And Chicago cured him of that. But that's obviously just speculation.
Yeah, thank you. I think it's a great question, Daniel. And so one of the things I'll say is, the Black Greek letter organizations, I think, do constantly ask and want to re-examine not their mission, because our missions, I think are stable and still necessary, but examine how to best effectuate those goals. So each organization has its own objectives. Kappa Alpha Psi has 5 objectives. The 5th one, which was the title of my talk, was to inspire service in the public interest. And the question is always how to best do that. I think the organizations still have continued relevance. We understand the way that it actually manifests itself is going to be different when you're combating de facto racism as opposed to de jure racism. Okay, so I think the efforts are going to be more notable in a de jure context than a de facto context. But I think the organizational kind of the capacity for collective action that the organizations have are just important as today as they were and generations prior. And so there are what we call 9 Black Greek letter organizations, 5 fraternities, and 4 sororities. There are actually more than that, but these are kind of the 9 larger ones who form a collective, and which is colloquially referred to as the Divine Nine. And not only do the organizations talk among within, but also across organizations and thinking about how to best collaborate. And really, I mean, broader than just anti-Black racism, but I do think about the current times we're in and dealing with that as well. So I'll just give 2 quick anecdotes to give a perspective. So one, when I was an undergraduate at the University of California, Davis, Proposition 209 was on the ballot. And I'm going to mention this because now Proposition 16, which is to repeal Proposition 209, is on the ballot now in California. And for those of you who haven't had the pleasure of being in California long enough to know what any of those propositions are, Proposition 209 was the proposition to repeal affirmative action. And Proposition 16 is, among other things, a proposition to reinstate it. But while I was an undergraduate at the University of California at Davis, not only just Kappa Alpha Psi, but then also the other Greek letter organizations, and all of them were represented on my campus at that time, met to best work against or to try to defeat Proposition 209. We were unsuccessful. But the way we went about in terms of getting information out, encouraging individuals to vote, phone banking, and so forth, all of that was done, and it was made a lot easier when you already have an existing organizational structure. Similarly, those things are being done now, and I've talked to some of the undergraduates even here at the University of UCLA, as well as members of my alumni chapter, and similar efforts are being made. So that's just one example of how I think the organizations still are involved today.
Thank you, Professor Thaxton, Professor Strauss. We're a little over time. I'm not able to get to all the questions that came in, but we're due a break now, and we will reconvene again at 1:50. Thank you so much.